Hello and good Sunday morning to you all. I'm John Hunter. I'm a criminal defense attorney in San Antonio, Texas. And the events of the weekend have prompted me to make this video to try and address a couple of things that are being talked about excessively on the internet and that I don't think people quite get a hold of. I don't pretend to be a complete expert on all questions of international law, but I have handled a great many foreign-related drug trafficking cases that have involved several of the questions that are tied up in the recent arrest of President Nicolas Maduro of Venezuela that I think would be important for people to know about as we have this conversation. This is obviously a very complicated area of law, but it is not that complicated because if we want to boil it down to basic principles, the United States has for a very long time, through its legal jurisprudence on the question of extradition, personal jurisdiction of foreign defendants, time and again sent a clear message that we are not to be trusted with respect to our treaty obligations to other countries. We are not to be trusted with respect to our appreciation and deference to questions related to foreign sovereigns. And that is now made apparent and manifest in a way that frankly shocks the conscience, and that has always been the underlying implication of what these judicial decisions have implied. But it is not something that I think anyone expected would actually ever come to pass. If ever there was a case to be made for why slippery slope reasoning sometimes is not a logical fallacy, this would likely be the case study example of that. So the first thing you need to understand is that for a court to prosecute someone for a criminal act, they need to have personal jurisdiction, which means that that person needs to be in the country and in the custody of the court. We arrest people and we commit them to bail, or we hold them because they cannot be bailed. And that is the basic idea. If we have them, then we can prosecute them, period, full stop. The question then becomes, how do we get them? And for a lot of people, issues related to this are immediately calling to mind questions regarding the law of extradition. Extradition is a body of law that relates to how countries agree by treaty to handle requests and demands for individual people who have been accused of a crime in the demanding country and who are currently living in or hiding out in the harboring country. And typically, when that happens, a person is charged with a crime in the demanding country, and their State Department make requests to the host country saying, we want this person to be prosecuted for a criminal act that we believe occurred or violated the laws of our nation, and we want them to be produced. And then there will be a process judicially imposed in the host country to determine whether or not that person is subject to the treaty that they have signed with the United States regarding extradition. And they're looking at things like comity. They're looking at things like equivalence of criminal conduct. So, for example, if the person has done something that is against the laws of the United States, but it is not a crime in the host country, and the treaty that they have signed with the United States expressly exempts those types of offenses from its purview, the host country may not have to give up the person because it wouldn't be a crime. Similarly, a lot of such arrangements like we have with the European Union recognize that that Europe will not extradite to the United States when there's a risk that capital punishment could be imposed, for example, unless the government makes concessions that they will not seek the death penalty. This is obviously for the ideological conflict that in the United States, the federal government and many of our states still recognize the death penalty, but in Europe, it is, I think, categorically banned. And so if there's a huge discrepancy in what kind of punishment can be doled out for the offense between the host country and the demanding nation, sometimes that can block extradition. But understand, all of these principles are basically contract law. They are predicated on the fact that a treaty was negotiated between the heads of state and ratified by the Congress in the United States. We've signed on to it, and we have promised those other nations that we would abide by these rules and principles when handling extradition both to the United States and from the United States. And as the United States has historically done, we are notorious for breaking our contracts with other nations. We broke almost every contract we ever made with the Native Americans, and we have broken many, many contracts that we have made with foreign governments around the world. So there's this question. And so we end up in a place where one might think that if the law of extradition has not been scrupulously honored, that might somehow defeat the personal jurisdiction that the federal government would have over that individual who's been brought to the U.S. soil. But unfortunately, that has historically not proven to be the case. There is a concept called the Kerr-Frisbee doctrine, which has said that even in cases in which the extradition to the United States was illegal, unauthorized, or even perpetrated using underhanded means or violence or cruelty in ways that would otherwise be violative of even our own laws, that these transgressions do not defeat personal jurisdiction. The person is here. And I have represented people who were apprehended in Latin American countries under pretty grotesque circumstances involving extreme violence, torture, misconduct by both government entities and paramilitary groups, that all of which culminated in the person being dropped off at America's doorstep. And none of those circumstances have availed, were available for the defendant to avail himself of. It nevertheless, his body ended up in the United States, even if it was unceremoniously dumped in the United States from a helicopter. Jurisdiction has attached and the criminal prosecution can move forward. On its face, I think it's fairly clear that that is a really bad set of doctrines. It lends itself to the possibility that the federal government could engage in extremely immoral and unscrupulous means to procure the personal attendance of a defendant in criminal court, even by doing so in ways that would blatantly violate the United States Constitution if they were done by an American citizen or a federal law enforcement official, and suffer no repercussions, in no way jeopardize the integrity of their case. And that really runs afoul of what the American justice system purports itself to be, which is that we hold ourselves to a higher standard in the way that we prosecute criminal behavior, because we recognize that even when we are accusing someone of doing something heinous, that individual person has rights, and those rights must be honored in the course of the process, or else it undermines the legitimacy of the punishment that we can dole out to them. It undermines the legitimacy of the entire system when we are willing to do things that compromise our moral integrity as a nation for the sake of securing a conviction for one particular criminal defendant. But that's the place where we have landed on this. There are some cases that have acknowledged that while the Kerr-Frisbee doctrine normally would operate against a criminally accused person in the face of whatever terrifying and awful means were used to secure their extradition to the United States, that in a case of extreme government misconduct, there might be a way to defeat the prosecution on that basis. But while that has been hypothetically discussed as a possibility, it has not been one that has been recognized in a concrete, actual flesh and blood case in America. And so the question has been for decades, what would be sufficiently egregious misconduct to merit that? Obviously, I think that knocking out the power grid to a major metropolitan city in a foreign country, bombing their military bases, and stealing their head of state and his wife in the middle of the night, and flying them to a foreign country might qualify as that for a number of reasons. For one, it is a flagrant use of the military in what is purportedly a criminal prosecution, but in all actual fact is an act of war. Engaging in an act of war unauthorized by Congress in order to secure the defendant's presence in federal court strikes me as perhaps an argument that would rise to the level of the egregious government misconduct that has been so flagrantly laughed at as a absurd hypothetical in the case law surrounding the Kerr-Frisbee doctrine. So that's a major point that needs to be discussed here. Is there a colorable legal argument for this type of an extradition to the United States? Yes, there is. But that's not the end of the story, and it's important to understand the history of the doctrine and its limitations in order to appreciate that what's being done here is unprecedented and terrifying. There will, of course, be lots of comparisons drawn between this and the arrest of Manuel Noriega in the 90s. There are a lot of similarities, clearly. That's an interesting aspect of this as well, because separate and apart from the question of personal jurisdiction, separate and apart from the question of extradition procedure and whether or not that was handled and whether there's a remedy for violation of treaty, there is the separate question of immunity for the head of a foreign state. We have historically recognized that for nations to be able to conduct business with one another and to be able to have peaceful relations with foreign nations, that except in times of war, there really cannot be a means or an instrument for one government to criminally prosecute the head of state of another government. And that as a result, those officials are generally immune from prosecution under our laws. The thinking being, if someone is violating our laws as head of state in a way that is sufficiently dangerous to the interests of the United States, the remedy would be a declaration of war, not to invoke criminal process. If we don't have that rule in place, then we have a pretty arbitrary means of doing business around the world, which undermines our credibility, undermines our ability to transact business and to make promises and to enforce those promises when they are made by other foreign governments. Noriega tried to invoke this doctrine when he was prosecuted, and the issue was addressed extensively by the 11th Circuit on his appeal. The basic question is whether or not that doctrine was sufficiently explored in the course of Noriega's prosecution for us to draw helpful comparisons to this. There are a couple reasons why maybe we shouldn't be so quick to rely on Noriega as some sort of a supporting precedent for what Donald Trump has done. The first is that there's a clear difference here between Maduro and Noriega, in that Noriega was never recognized to be the head of state of Panama. He was using heads of state as puppets. He was perhaps de facto the head of state, but there was, from the beginning of his tenure as a major political figure in Panama, serious question as to whether or not he had any legitimate claim to being the head of state. And the State Department had never recognized him as such. So in Noriega's case, there was an extensive discussion about under what circumstances does someone receive the benefit of being designated a foreign head of state. And regrettably, the 11th Circuit essentially punted that issue to the executive branch of government and said, well, if the executive says they are a foreign head of state, then they are. And if the executive says that they are not, then they are not. The more nebulous question that is not fully answered by the Noriega case is what happens when there has been no specific designation one way or the other by the State Department. What happens when we have been indifferent to someone's operation as head of state in a foreign power, and now, for whatever reason, political expediency, etc., we've decided that they need to be challenged as a legitimate head of state. Then the courts have said that there is a role for the judicial branch to play, that they won't defer to the executive. although this is not exactly a concrete rule of law because it is not entirely germane to what the court in the 11th Circuit was addressing with Noriega. It's being discussed as sort of a sideline question. Here, Maduro has been recognized by the United States government as a legitimate head of state. That legitimacy was taken away from him because there was a serious question related to the legitimacy of a presidential election that took place some years ago. And as a result of that, the State Department no longer recognizes him as a legitimate head of state. This really ties together one of the major problems of delegating this authority to the executive branch of government. It's my opinion, and I think that this is a position that we need to explore more deeply, that when determining whether or not a claim of immunity, which is a question of law, is applicable to anyone, whatever kind of immunity is being claimed, that the judicial branch plays a fundamental role in assessing the viability of that claim, and that deferring to the designation of the executive branch is incredibly dangerous. Because think about what we're talking about here. We're talking about Donald Trump saying someone is the head of state or someone is not the head of state. At that point, there is no check on the power. There is no limitation on what it can do. If he likes the head of France on one day and doesn't like the head of France on the next, he can engage his State Department to go through the diplomatic channel of revoking their designation as head of state. And now they have no protection from the full panoply of criminal law applicable in the United States so long as there's subject matter jurisdiction over the action. That's a impossible place to be in terms of doing business with the United States, with no guarantee that international law would be honored. You're being asked to treat with these people, to make deals, to agree to everything from trade to military resource and intelligence sharing, the whole kit and caboodle. And I don't think that that's a tenable place to be. The question of whether or not someone is sufficiently designated the head of state for the purpose of claiming immunity from prosecution should be something that the judiciary explores independent of what the State Department says based upon the direction of the President of the United States. And to have deferred that power, abdicated that power in the Noriega case is, I think, endemic of the big problem we are experiencing right now. Whether you are a conservative or a liberal, whether you are deeply invested in the Make America Great Again movement or you are vehemently opposed to it, all Americans, I think, should be able to come together and recognize that we do not want any one person or any one branch of government to have this much power to independently make these kinds of global, massive, world-changing decisions without the input of the other branches of government and then consequently the input of the American people. When those things happen, there is no limit to what the abuses can look like. And in fact, for a great many people who are supporters of Mr. Trump and the Make America Great Again movement, this was one of the major axes to grind. The left has legitimately put a great deal of power and authority in the regulatory bodies of the administrative state, which is part of the executive, which means that if you want to build a factory and there is some concern about what you will do to the nearby wetlands, the Environmental Protection Agency can just simply say that you can't build your factory, which many people perceive as being very anti-American in the sense that it's anti-business. And why is it that the EPA should be the final arbiter of whether or not that factory is safe to operate? Why should it be something that's so cut and dry that one aspect of the government without any oversight, is entitled to do that. People recognize that while there may be legitimate reasons why that factory can't operate, that it could also be used as a political tool to undermine that aspect of business and to weaken that business's ability to influence the Congress or to have a say in the commerce of the American experience. And people get angry about that. I get angry about that because the administrative agencies have for decades been authorized by Congress to, of their own accord, without the input of the Congress and without the input of the American people, create criminal law, manufacture criminal offenses that people can commit. And it's one thing if your congressman comes and says, we're going to make this a crime because it hasn't been addressed properly in the code, and we need to make sure that there are criminal penalties for it, and the Congress votes on it and the president signs it. But it's quite another thing when an administrative agency behind closed doors makes these rules, which have criminal penalty to it, and then almost no one can really be sure what's against the law and what isn't. Because, for one, no one has the time to go through all of the administrative code and identify what has been criminalized this year, what is up for discussion, all of those things, unless you are extremely niche interested in a particular subject. So this is something that the right and the left have both, at different points in time, correctly pointed out as a serious flaw in the way that our government has operated in the latter half of the 20th century. And I think that that was one of the great appeals of the MAGA campaign. And yet here we are. It's being dismantled in favor of all of that arbitrary and capricious exercise of power by one branch of government falling into the hands of one person, the president himself, which is an even more frightening proposition. This isn't to suggest answers to these problems. It's to try and cast a light on where we're going and why we're here. We're here because well-meaning people, well-intentioned, decided that the risks of a more grotesque variation of the American experience were outweighed by the immediacy of whatever problem faced them. Whether that's we need to make sure that the war on drugs is successful, whether that's we need to make sure that immigration enforcement is more efficiently executed, whether that's we need to make sure that foreign interests in major commodity extraction like oil and gas are being protected. Those interests have won over against our core principles as a country and against our values. And you can only do that so many times before there is a palpable erosion of what makes your country your country. And we are approaching that. We are approaching that at a light speed pace. So, thought I would share these thoughts with you all, and I guess we'll all stay tuned. Proves to be another riveting week of television.